Hello students, how are you? It's good to it's good to connect with all of you and wish you all good luck for the May 2021 examinations. Let me begin by telling all of you that the topic assigned to me is a very important and interesting, at the same time complex topic. Taxation of charitable and religious trusts, institutions, political parties, and electoral trusts. This is the topic which is assigned to me, which I have to cover in today's session and the session day after tomorrow. That is on Thursday evening at 6 p.m. Now, for your exams, May 2021 exam, the relevant Finance Act which is applicable is Finance Act 2020. Hence, I will be factoring in the amendments made by the Finance Act 2020 to the extent it is relevant for your examinations. There is a clarification of the Board of Studies that the relevant assessment year for your May 2021 exam will be assessment year 2021-22. So we have to deal with the provisions applicable for assessment year 21-22. I'm also aware that these are regular classes, not a revision class where we expect the students to have read the chapter and come for a revision before the examination. So we have in mind the students who have not read this chapter at all and are reading with me for the first time. We have students who have not read this chapter in our mind, and we are going to come down to that level and introduce the provisions applicable for this chapter. After introducing the provisions, for the final level, whatever is the expertise required, whatever is the depth of knowledge required, we will take you to the advanced areas applicable in this chapter. So those of you who have not read this chapter would be able to be with me and understand the chapter. Those of you who have already had the occasion to read it in office or apply it in your articleship period, kindly bear with me, and after the introduction of the provisions, we will take you to the advanced areas which will be relevant from the point of view of your final examinations. These are the preliminary observations I would like to make before I commence the chapter. Now, let me begin after this small introduction. This chapter is very, very significant and important, both from the examination point of view as well as in a practical view. Now, in our country, we have many people who have the resources and who have the willingness to contribute the resources for the less fortunate people. They are prepared to contribute. And these type of people who are resourceful and would like to contribute for the upliftment of the weaker sections of the society are called donors. Although these people have the mind to spend, they are not having the time or the setup, organization to identify the weaker sections of society and contribute to them. And the other people who require the support, who are not so fortunate, they require some assistance they require some hand-holding, they require some sort of support. So these two people have to be connected. And the institution which connects these two groups of people is the trust and the institution. The trust and the institutions do a very commendable job in our country. When I say commendable job, they contribute as well as administer. Now, what is happening here is the trust and the institutions collect the money from the donors, approach the donors, take their contribution, identify the true beneficiaries, and distribute to the beneficiaries in some form or the other. So strictly speaking, the trust and the institutions are a pass-through entity. They collect and distribute. So this is the role of the trust and the institution. So Income Tax Act wants to recognize the good services rendered by the trust and institutions, and would like to give exemptions to the trust in respect of the income which the trust is getting, because they are not taking it for themselves, they are going to pass it on to the beneficiaries. So when they are keen to give the exemptions, at the same time, the Income Tax Act or the Income Tax Department would like to cross-verify, would like to satisfy themselves that the amount is actually spent for the benefit of the weaker sections of the society or for charitable purposes. They would like to doubly check that. So they would like to monitor the activities of the trust and institutions. So what is happening is, there are 4 aspects which the Income Tax Department would like to check. The first one, whether the objects are charitable, or in the guise of charitable activities, something else is being done. So they would like to see whether it is spent for charitable activities. The second thing which they would like to verify, I'm talking in general, they would like to verify, is that there should be a time frame within which the amount should be applied for charitable activities. If the trust is going to take an unduly long time, then the purpose for which it is contributed gets delayed. They want the trust to spend it within a definite time period. This is second requirement. One, whether the objects are charitable. Second, whether they spend it within a definite time period. And third, they should not spend it to their own relatives or related parties. The trustees cannot give it to their relatives, or the donor cannot give it to their relatives. They don't want the money to go to the related parties. And lastly, till such time the money is spent for the benefit of the beneficiaries, it should be safely kept in some identifiable government or notified securities. These are the 4 aspects. You remember these 4 aspects: objects, charitable purpose, definite time period, it should not be spent for related parties, and the safety of the money. Just imagine, in our country, when there are so many trusts and institutions, whether the Income Tax Department could monitor all these trusts spread across the country. It's a very difficult exercise. And therefore, they have introduced an audit process. They introduced an audit process and give a mandate to the chartered accountant who is doing the audit to prepare a report in a specified form, which will give meaningful information to the Income Tax Department to identify whether the trust complies with the requirements which are highlighted, the 4 requirements which are highlighted. So that is very, very important, and that's the role of the chartered accountant who does the audit. And the audit report form also is mentioned there. So having said this, I now go into the next area. Before I go into the subject proper, let me introduce certain terms associated with the trust. Trust is an obligation created by a person. The person who is willing to contribute and create the trust, he is the founder. He is called the author of the trust. The author of the trust, he has got a building or he's got some investments, he's got some business, he will give it to the trust. And the person who creates this obligation is called the author of the trust. And this trust should be created by means of a document. Now, if you see the Trust Act, oral trust also is valid. But if the trust wants exemption under the Income Tax Act, the trust should be created in the form of a document. The author of the trust should write a trust deed and give out the objects of the trust and name the trustees. There, it should be created by means of a document, and that document is called as the instrument of trust or a trust deed. And you cannot simply create a trust. There should be a link with the trust property. Either the author should give some investments, or he should give a property, or he should give a business. It should be linked with some property. You cannot simply direct the trustee to make profit on their own and spend it for charitable activities. There should be a link or a connection with the property. This author in the trust deed will nominate some persons to administer the trust. And the persons whom the author nominates to administer the trust, they have trust in them, and hence they are called the trustees. And finally, the person for whose benefit the public at large, the weaker sections of society, they are called the beneficiaries. These are in quick terms, the terms which are used, which we'll be using in our presentation, in examinations, in any standard literature on taxes. They will definitely use these terms. So you must be familiar with these terms. Having explained this aspect, I now go into the next area, the classification of the institutions. The classification of the institutions, I will put it like this. First group, go to the first block there. You are able to see the presentation on the screen. The first block is university, education institutions, hospital, medical institution. These university, education institutions are connected. Hospital, medical institutions. Specified charitable religious institutions are funds notified under section 1023C. This is one class of charitable institutions. So you must remember that. Second group, if you move to the second block there, trust institutions for charitable religious purposes. The relevant section numbers applicable to charitable and religious institutions are sections 11 to 13. Section 11 says the income is exempted subject to conditions. Conditions are spelled out in 12 and 13. All the three sections are relevant. So the second class of institutions is charitable religious institutions. Third one is a political party. The income of a political party is exempted subject to the conditions specified in section 13 capital A. So this is a third type of institution. The fourth type is the electoral trust. An electoral trust is a constitution where people at large can contribute to the electoral trust, and they will give a bond, and that bond can be given to the name of the person who subscribes will not be given. Anonymity of the person contributing will be maintained, And afterwards, the bonds will be given to any political party. They will go and encash it from the electoral trust. That's how electoral trust work. In the process, the electoral trust may make some profit. That profit is not chargeable to tax, subject to the conditions specified in 13B. So these are the 4 types of institutions which we will be covering in our presentation. Not necessarily in the same order, but these are the institutions which we will be covering. Having explained all these things, now we will come to the trust, different types of trust. One, we have a public trust, and the other one is the private trust. The private trusts are governed by the Trust Act 1882, old one, Trust Act 1882. So a new legislation has come now, we have to see that. But private trusts are governed by the Trust Act 1882. Now, this private trust can be further categorized into 2 categories. 1, a specific trust, and 2, the discretionary trust. A specific trust, you may be curious to know what exactly is the difference between a specific and a discretionary trust. A specific trust is a trust where the beneficiaries are listed. The person who creates the trust tells who are the beneficiaries. He not only tells who the beneficiaries are, he also informs the share of each beneficiary. The share of each beneficiary, it's specified there. So to be categorized as a specific trust, the beneficiaries must be definite and the shares of the beneficiaries must be definite. Both must be satisfied. A discretionary trust, beneficiaries are not specified, or the beneficiaries are specified but the shares of beneficiaries are not specified, then it is a discretionary trust. Now, we are not going to deal with this, but I am drawing a reference section number for your future reference. When you are reading it, you can read. Specific trust is charged to tax under the provisions of 161 of the Income Tax Act. Discretionary trusts are charged to tax under section 164 of the Income Tax Act. So I have drawn your attention to the relevant section numbers, section 161 and 164. We are more concerned with the public trust in this chapter. In this chapter, our focus is going to be on the public charitable trust. Now, a list of 5 points are coming there. The beneficiaries here must be public. Public, not necessarily a few people, or a class of public. There could be people who will be affected in their own family by a disease, a terminal ailment like cancer. And this person, after starting his career, makes some good money, and he remembers his relative who suffered because of the disease. So he may create a trust for the benefit of the people who do not have the facility to meet medical expenses suffering from cancer. Therefore, it's a class of public, people suffering from cancer and do not have the means for medical treatment. So you may create a trust for that class of public people, or somebody may create a trust for the widows, for the people who are not, where income level is below a particular level and they don't have facility to continue their education. So it could be a separate class of. And what is very, very important, and a legal point which I am trying to convey to all of you is, this public charitable trust is not governed by the Trust Act 1882. It's not governed. So if it is not governed, somebody could raise an issue that the sections 11 to 13 are not applicable to public charitable trust because it is not covered not governed by Trust Act 1882. To overcome this objection, if somebody puts a question like this to you, you must be able to answer. That is why a trust is the public charitable trust is treated as a trust under sections 11 to 13 by virtue of explanation 1 to section 13. Explanation 1 to section 13 says a trust for the purpose of this sections 11 to 13, for the purposes of sections 11 to 13, includes any legal obligation. Any legal obligation. Very specifically, they said, for the purposes of 11 to 13, a trust includes any legal obligation. And when an author of the trust creates a trust, he creates a legal obligation for the trustees to administer the trust. Therefore, the sections 11 to 13 are applicable. Now, mind you, 11 gives you exemption. 12, 13 and all gives you certain conditions for claiming the exemption. But what is the income of the trust? If you refer section 224, I'm going into details. 224 clause 2A, I've given the reference number there in the slide. Strictly speaking, all of you are aware at the final level, all revenue receipts are income and charged to tax. Capital receipts would be charged to tax if there is a specific provision. If I contribute to a trust, if I give a donation to a trust, it is a capital receipt. Strictly speaking, it is not income. It cannot be charged to tax. That is why in the definition of income 224, there is a very specific clause. Voluntary contributions received by a trust is treated as income. It's a provision, very specific provision. I told you capital receipts could be charged to tax if there is a specific provision. And the specific provision is there in 224 of the Income Tax Act, clause 2A. Income includes voluntary contributions received by the trust, all voluntary contributions, whether regular or corpus. I'll explain what is corpus a little later. So what happens here is the voluntary contributions are treated as income. But you remember that explanation to section 13 says that a legal obligation will be considered as a trust only for the purposes of 11 to 13. So when we people read the income tax law with details, we would say it is treated as a legal trust only for purpose of 11 to 13. It is not treated as a trust for section 224. Hence, explanation to section 224 clause 2A says that a legal obligation will be considered as a trust even for this section. So, although the public charitable trusts are not governed by the Trust Act 1882, the provisions of the Income Tax Act 224 as well as 11 to 13 will apply to a public charitable trust. Hope this is clear for you. This is a very technical point which I brought it out for you. Kindly remember this point and then you will understand. Now, before I go into the next aspect, I would like to tell you, whenever you are reading a big chapter in income tax law, whatever chapter, maybe big or small, doesn't matter, what I would suggest is try to condense that chapter into small charts like this and try to recollect from this chart. Try to list out the salient points. And in this particular presentation, I'm going to add one more feature. What I have done in the presentation, as we proceed, you will find some of the points I will be putting it in a different color, red color. I use the red color. Red color signifies amendments made by Finance Act 19, amendments made by Finance Act 2020. So anything which comes as an amendment gathers more importance from the point of view of examination. So Finance Act 19 and Finance Act 20, any amendment, I have captured it in red color. Second, whenever there is a controversial issue where two views are possible, assessee says one view, department says another view, the matter has gone up to the High Court or Supreme Court, and there is a judgment. 4 or 5 areas like that are coming. I put that in red color. And something else which is very, very significant, very important, that could trigger the interest of any examiner, that also I have put in red. So what happens is, for you, instead of reading 80 pages in the book, if you look to the presentation, you get the salient points. And in the presentation, if you look into the red color points alone, which is put in different color, and try to narrate the important aspects as many times as possible, you will never forget it. The problem with final direct taxes paper is it is so voluminous, so huge, that to revise it the day before the examination is very tough. Hence, if you are able to condense it in the form of these charts like this, it will be definitely easier for you to recollect. And while running through this chart, concentrate and focus on the red color points, which will help you to recollect faster. Having explained this, now I will go into the income of a trust institution excluded from total income subject to conditions in 11 to 13. The charitable trust can be divided into 2 categories. Income from property held under trust for charitable religious purpose in India. The object of the trust is to do charitable activities in India. That is one category. And the other category is object of the trust, income property will be used for benefit of people internationally, benefit of global benefit. They could have like this. I will tell you more about it. We are more concerned with the charitable activities in India because you will know the importance of it in a short while from now. Then we see income from property held under trust wholly for charitable religious purposes. Whenever registered, it could be registered at any point of time. Then it should be wholly for charitable religious purposes. The second category is income from property held under trust in part for charitable religious purposes. But here, please be careful. I am cautioning you. I am drawing your attention. If a trust property is created in part, that if you want to claim the exemption, that trust should have been created before 1st of April 1962. Therefore, if you create a trust today and say the property is going to, part of the property, income from property is going to be used for charitable religious purposes, you will not get the benefit of the exemption. I'm making it very clear. No exemption will be available to you because if it is created after on or after 1st April 62. So today it's not so. But supposing the trust has been created before 62, what is this wholly and part? Assuming I have a property, big building, I give it to a charitable trust and say the entire income from the trust should be used for the objects of the trust, then it is wholly for. If I give a property to the trust and say 60% of the income from the property should be used for charitable activities and the balance 40% should be given to X, Y, Z to whomsoever I say, then it is part. If I create a trust in part, then it is not, and we created on or after 1st April 62, you will not be entitled for the benefit. The third box which is coming up is that what is the income of a trust? Voluntary contributions, including corpus contribution, is the income. But corpus contributions are exempted. Exempted if the trust complies with the conditions. So voluntary contributions, including corpus contribution, will be considered as income initially, and then the corpus contribution will get exempted because if the trust complies with the condition. Now, I have to clarify for you what is voluntary, what is regular contribution, and what is corpus contribution. If a donor is going to give a contribution to a trust and instruct the trustees, give a mandate to a trustees that it should be used for only, the money should be kept, retained by the trust, and used, interest on that should be used for charitable activities. If he gives the direction, mandate like this, then it is corpus. The trustees will not have the power to spend that money, but they could retain that money, earn some income out of it, and that income should be applied for charitable activities. If the donor gives a mandate like this, it becomes corpus contribution. If the donor makes a simple contribution without giving any mandate, it becomes a regular contribution. Both contributions are treated as income, but corpus contributions are exempted if the trust is registered and many other conditions are satisfied. Hope I'm making myself clear up to now. And now we go into the other aspects. See, if it is created for international purposes, there is another small thing which you have in mind. This is less important. We need not spend too much time. Just 1 minute, I make a mention about it and pass over. Created on or after 1st April 52, not 62, it's 52, 10 years I have before that. If it is created on or after 1st April 52, the application should be for international welfare in which India is interested. You cannot use it for any international charitable activity. That international charitable activity, India should be interested. Then only it is eligible for exemption. Otherwise, it's not eligible for exemption. Created before 1st April 52, if the income is applied to such purpose outside India. If you apply that income outside India, but if it is created before 1/4/52, okay? So this is less important. I just, to cover the area I have told you, I don't think we should spend more time. And third box is the same thing, voluntary contributions received by this trust will be treated as income, including corpus contribution, but the corpus contributions are exempted if the trust is registered and complies with certain other conditions. Is that okay with you? Because this is of less importance, I am passing it over. Now, before I go into the other aspect, to my mind, don't be guided by 3 sections in this charitable religious institution chapter. 3 sections are enough to take a good part of your time, the way it is drafted. So don't say it's only 3 sections. It's much more than 3 sections. We have to focus our attention and try to understand the nuances, difficulties in these sections. I have divided this chapter. I have identified 13 crucial issues, 13 aspects, 13 segments of this chapter. I am going to list out these segments in the next 2 slides. In the next slide, I will be listing out 6 important aspects of charitable trust. The subsequent slide, I will list out the remaining 7, 6 plus 7, 13. And each one of them, I will explain during the course of my presentation. Each one of them. So, I'm listing out the first 6 conditions for claiming and computation of exemption. Objects of the trust, I told you, must be for charitable or religious purpose. Object should be charitable or religious. Second, what is the definition? What is the meaning of charitable purpose? Which is defined in section 2, clause 15. Or what is religious purpose? The definition, which is very, very important. Third requirement is that if you want to claim exemption, the trust should be registered. You should get it registered with the income tax department. Section 12AA gives the mandate. The Finance Act 2020 added another section, 12AB, but fortunately it got deferred. Because of the pandemic, it got deferred. So if you want to claim exemption, the other aspect is registration. And what are the difficulties in getting the trust registered? What is the procedure you have to follow? We have to understand it in detail. Then we have the components of income. What are the income of what will be considered as the income of the trust? What are the different types of income, components of income, and application of income? I told you in the initial slide or initial introductory remark that the income tax department is interested to find out and see that the amount collected is spent for charitable activities within a definite time frame. Therefore, this aspect is you must apply the income for charitable activities within a specified time. What are those details? We have to understand in detail. When they say you have to apply it, sometimes for genuine reasons. For example, you take the pandemic. Many trusts were not able to apply the money. I know of a trust which is doing activities for the blind persons, physically challenged. They are physically challenged. They don't have full visibility or they cannot see properly. And for that type of children, they conduct a sporting event. They teach them how to play a game with a ball, for which they have developed certain special types of balls and make them involved in it. Now, they spend a lot of money for this purpose. Now, they were not able to do it for 8 months because of the pandemic. So whatever money they have allocated for that activity, they are not able to spend. Like this, there could be some practical difficulties in applying the income. When such difficulties are come, they say it's deemed to apply it. That is the sixth aspect. So you must focus on these areas and try to understand the importance of it. 6 I have covered in this slide. The other 7 are coming here. Accumulation or setting apart of income. So what happens here is trusts may have some bigger projects in mind. If they spend whatever they get during the year itself, and if they want to do a bigger project, they will not have money to. All of you are doing CA. The moment you finish your CA and take up a job, and 3 years down the line, you want to buy a property, residential property. And with residential property, you will not have sufficient savings to buy a residential property. So you have to necessarily take a loan to buy a property. But you will say, no, I don't want to take a loan. I will buy the property as and when I get the savings. By the time you save enough money to buy the property, the value of the property will go up further. You can never acquire it. And that is why they take loans and they buy the property. Similarly, if the accumulations, if they're going to spend a good part of the income during the year, they cannot do any big project. They want to construct some shelter for the economically weaker sections. They want to construct a school like this. So they could accumulate income. So there's a separate thing for it. Until such time you use it for that purpose, it should be safety. I told you earlier also, the safety of the money is important. It should be invested in specified modes of investment. In section 11.5, they give a list of investments. You have to park the money only in those investments and you cannot put it anywhere you like. Then how to compute the income? What are the provisions for computing the income? Anonymous donations. Anonymous donations are a very important aspect. What are the treatments? So slowly, one by one, they added to the charitable trust. And the 11th one, 10th and 11th are very, very important. Accredited income, otherwise known as exit tax. When the trust is being wound up, closed down for so many reasons, what they should do, what they should not do. And if they don't do certain aspects, they don't comply with certain requirements, they have to pay a tax known as exit tax, the details of which we have to understand. And the 12th point is they put certain conditions, and if you don't comply with the conditions, the exemption will be denied. How the exemption will be denied is listed on what situations the exemptions will be denied is listed out in section 13. And the last point, 13th, is provisions related to compliance and audit. I told you the income tax department cannot virtually or realistically look into the accounts and records of all the charitable institutions. So they have an audit process and they have to get the report in a specified form. And the report has to be submitted within a particular date. All these things are relevant. So these 13 points are very, very important to understand the full chart. If you cover all these 13 aspects, then you could say you have a firm grip of this chapter, assessment of charitable and religious trust and institutions. This is about this sort of a overview of what we are going to cover today. Not for the day, for today and for the next class. Now we go into a very important aspect. The first one I said is, if you remember, objects must be charitable or religious. I've got nothing to explain there. When you list out the objects, it should be you cannot say something which is to do a risky business or to do any type of business. You cannot put like that. You must say, I'm going to help the weaker sections. I'm going to give education to the weaker sections. Like the objects must be charitable in the trust deed. Now coming to the definition of charitable purpose. Section 2, clause 15 defines charitable purpose. Charitable purpose includes, it's an inclusive definition. Whatever they have listed there is only an illustrated list. Something else similar to it could always be added. Includes, inclusive definition. And this definition is in two parts. The first part I will be bringing it on the screen now. And then after explaining the first part, I will come to the second part of it. First part includes relief of poor. If you are going to do an activity which is going to provide some relief to the poor, if you get involved in education activities, education of the weaker sections of society, or give some support for education, yoga, they added it recently, yoga. To the fast moving world, this is absolutely required. Concentrate. Because today, the span of attention of people is getting reduced because of the distractions. So yoga will help you to focus. So if somebody is going to help in understanding yoga in a better manner, then that institution will be considered as a charitable institution. So three aspects I have said: relief of poor, education, yoga. Medical relief, that's very expensive these days. Many people cannot afford the medical treatment. So if a charitable institution is going to extend their helping arm to the people for medical relief, these four aspects. The fifth aspect is generic in the sense Preservation of environmental monuments, places, or objects of artistic or historic importance. When I say of environment, they very specifically put within brackets, including waterways and wildlife. To protect the waterways, to protect the wildlife. We got the Tiger Project. We got so many projects to protect wildlife. Some animals which go extinct, they would like to protect them. So preservation of environment, including waterways and wildlife, monuments, places, or objects of artistic, historic importance. This is first category. This first category has got 5 elements. Poor, relief of poor, education, yoga, medical relief, preservation of environment, monuments, places, etc. This is the first part I would like to say. The second part is a generic one, is very general. Naturally, any person who is drafting a law would find it difficult to put all elements of charitable activities in letter. It's very difficult to draft a law like that. So having listed out the specific areas of charitable activities, they add a general category which says that advancement of any other object of general public utility. Advancement of any other object of general public utility. If you do an activity of general public utility, that will also be considered as a charitable purpose. Very clearly they mention. I know there is a confusion in your mind. What is meant by any other object of general public utility? Let me give you an example. I can give you, two examples. Example number 1. We have many chambers of commerce. What did chambers of commerce do? They collect subscription from their members and they provide some support to the business community to do that business in a proper manner, to improve their business, to develop the skill sets in business, give information, government, or make representations to the government. So chambers of commerce, what they do is they collect money, collect information, give training to their members. Now, if that is the case, are they doing relief to the poor? No. Are they providing education? Not necessarily education. They can just give information. Yoga? No. Medical relief? No. Preservation? No. But are they contributing for a general public purpose to improve the quality of the public at large? Answer is yes. Therefore, they are carrying on any other object of general public utility. And if they carry on a general public utility, that is also considered as. The other example I wanted to give, which is there in the institute material also, is they have got diamond merchants. Diamond merchants form themselves into an association. And the object of the association is to collect information and give it to them. It's more or less like a chamber of commerce. It is specifically only for diamond. Chambers of commerce may cater to the entire business community. Diamond Merchants Association is only catering to the diamond merchants. Now, they also could be considered as an activity of general public utility. So what happened when this definition was worded in this fashion and left as it is? There arose a situation when few of the institutions what they do is, of course, there's one question by Sumit Jain, like yoga services given by private companies are not charitable trusts. Yes, if a private company is going to do a yoga session as a business proposal, then they will not be considered as a charitable activity. If yoga services are going to be given to the public at large at a nominal fee or at free of charge, and the expenses are going to be met out of contributions made by the public, then it could be considered as a charitable act. There are private companies which are charging a princely amount, and only the affluent class of people can go for such type of yoga sessions. That will clearly not fall under the definition of charitable purpose. Because later on, when I talk about registration of the trust, one of the requirements of the for registration trust, the trust should be genuine. The Commissioner of Income Tax, the Principal Commissioner of Income Tax, who grants the registration to the trust, will see whether the activities of the trust are genuine. And when the trust is going to charge the people, and if the institution is going to charge the people, and it's a private company, the object of the company is to make profit, then it will not be considered as a charitable activity. So, advancement of any other object of general public utility, I gave you 2 examples. But what happened when the section was only this much? Then a few of the institutions who fell under the category of any other general public utility started doing activities which had a commercial flavor. Commercial flavor, which had a just like Sumit Jain was asking, private companies saying that they are doing yoga, but it had more of commercial business elements in it rather than charitable activity, rather than helping the public at large. So what happens when many institutions found an escape route like this? So they added an explanation, which is very important. Now you see here, advancement of any other object of general public utility shall not be charitable purpose. It is not considered as charitable if it involves any activity in the nature of trade, commerce, or business. That's exactly is what Sumit Jain said. If it involves any activity in the nature of trade, commerce, or business, if it has got a business flavor. So if you do something like this, and if it is it is commercial nature, then it will not be considered as a charitable purpose. Very clearly they brought it up. See, just imagine when the definition was like this. When the definition was this much, few institutions took advantage of these definitions and roped in a business activity also as charitable activity. Wanted to treat the business activity also as charitable activity. But then they put this condition. It will not include anything which involves the nature of trade, commerce, or business, or any services in relation to trade, commerce, or business. It will not include. When they did this, it created another problem. What's the other problem? I'm genuinely a charitable trust. I do charitable activities. I help the poor people. I'm doing everything. But I did one small transaction which has got a commercial flavor. Only one small thing I did for, say, few thousand rupees. I do charitable activities for a few crores of rupees. But a few thousand rupees I did charity for a commercial flavor. So they have to carve out that. Okay. Before I go into the carving out, there's one more thing. Whether if you have that business, whether for a fee, cess, fee, or any other consideration, the institution may collect a cess, fee, or any other consideration. Then what happened? The trust started arguing. The institution started arguing. Why are you so much concerned about it? What is the problem? After all, I'm doing a small activity, business activity, commercial activity. I'm making some profit and I'm deploying it for the objects of the trust. I'm helping the other poor people out of this income. When I'm helping the poor people out of this income, why should you be concerned about it, and why should you ask us to deny the exemption to us? They started arguing like that. To overcome that, they put this one, irrespective of the application of income. Whether they apply it for charitable objects or they don't apply it for charitable activity, this will not be considered as a charitable purpose. If there is some commercial element in it, it will not be considered as a charitable act. So this is what is very, very important and significant. How Padmanabhan from Trivandrum has asked a question, how a Chamber of Commerce can be considered as furtherance of any other object. You see, when there is an activity to help the public at large to do their activity in a better manner. After all, if you take education also, why we want to give education? Because over a period of time, if these educated people come out, they will be able to stand on their own leg. So we are trying to improve the living standards of people. That is education. Similarly, if the chambers of commerce, the information which was in the package, in the vicinity of only a few limited people, that information is being made available to a more cross section of the people. Chambers of commerce are helping the business community to do it. Then that is why we try to classify it as a general public utility. And this is a really example which we could take. So they carve it out, and if they do more of this commercial flavor, there are certain institutions which under this guise, under any other public utility, would like to do more of business activity. If they do that way, they come under this exclusion, and they will not be considered as a charitable purpose. So if they do a small thing also, they will be denied the exemption. Hence, they added this one. One more thing they added. The above limitation will not apply. The limitation that it will not be considered as a charitable purpose will not apply if aggregate receipts during the previous year from the activity do not exceed 20% of the total receipts. If the aggregate receipts do not exceed 20% of the total receipts, then this limitation will not apply. They will be considered as a charitable purpose. One more thing which is relevant and important here in this definition, which you have to capture, is that this limitation of the turnover being from the commercial activities should not exceed 20% of total receipts is applicable only to the second part of the definition of charitable purpose. It's applicable only to a trust carrying on any other activity of general public utility. It is not applicable to a trust carrying on education. It is not applicable to a trust carrying on relief to the poor. It's not applicable for them. They could indulge in some business which is incidental to the objects, and even if the receipts are more than 20% of the gross receipts, they will continue to get the exemption. This limitation of 20% receipts of total receipts is applicable only to those institutions which are coming under the second part, any other activity of general public utility. Have this in mind. This is very, very important, which you have to remember. Having explained the definition of charitable purpose, if you read some standard literature, in the words of education, what is education? There are many case laws, because there is one wider view for the meaning of the word education. There's a narrow view also. So there are so many things we have to understand. Sufficient for the purpose of examination. If you take this much and try to understand the meaning of charitable purpose to this extent. Now, consequence of violation. The income will not be eligible for exemption, will be chargeable to tax. Okay. One minute. Yes, very important. Thus, assuming a trust which comes under any other activity of general public utility does some commercial activity, receipts from the commercial activity exceeds 20%, what will happen? The income for that year will not be eligible for exemption, and it will be chargeable to tax. Income from that year Yes, I'll come to it. So, Padmanabhan, I've got your question. I'm just listen to me for this slide and the next slide. Your question will get answered. The income will not be eligible for exemption if you violate this. If the income from that activity exceeds 20%, then the income will be chargeable to tax. This is volatile. Second bullet point is very important. This is volatile because this year my receipts from the commercial activity exceed 20%. And hence, I lose my exemption. Next year, income from that activity will be less than 20%. I can get the exemption. So each year it may differ. That's why I said this is volatile, will change year. It will be chargeable to tax even though the registration is not cancelled. Supposing I cross the 20% limit, will the principal commissioner of income tax cancel my registration because I crossed that? No, he will not cancel. And even if the registration is not cancelled, the income will be chargeable to tax. The exemption will be denied. That is very important, which you have to remember. And I'm going to refer to the consequence of violation later while discussing accredited income, taxation of accredited income, otherwise known as exit tax. Later, I will be referring to this. So I'm just cautioning you now itself that we have to link it up with the exit tax provisions, accredited income, and understand this. Now, having said so much, we have to go to the next area of definition of religious purpose. But Padmanabhan has asked a question, and I have to answer that question. There is an education institution which is carrying on a business, a commercial activity, and it maintains separate books for the commercial activity. Now, Act itself provides a trust carrying on education activities can indulge in business activities, but the business activities in which they carry on should be incidental to the objects, and they should maintain separate books of accounts. If they do it, then the income from the charitable activities, income from the business, both will get exempted, subject to conditions. So it is possible. So the answer is question, if we have institutions coming under the first category, they are permitted to do business incidental to the business, and their receipts can exceed 20%. Their income will continue to get exempted. Subject to the condition, they maintain separate books of accounts. Two conditions: it should be incidental to the objects, and they should maintain books of accounts. These later on, how to compute that business income will come later. So this is one aspect which I wanted to cover. Now coming to the religious purpose. The term religious purpose is not defined in the income tax law. So we have to go to the general meaning for the word religious purpose, for the phraseology religious purpose. It would include advancement, support, or propagation of a religion. Somebody is going to tell the good qualities of a particular religion and gather support for it. Try to spread it among more people. So that is religious activity. Third bullet point is a distinction between charitable and religious trust. Charitable trust must be for the public at large, or a class of public, which I told you. But religious trust may be public or private. Maybe public or private. It is here I would like to give you an example of what a private trust could be, or private religious trust could be. The example is something like this. In our country, in India, there are people who own a large house in this house, a building in a large compound. And near the entrance to the compound, they'll have a place of worship. And to monitor or to administer this place of worship, they'll create a private trust. They will create a trust, nominate a few of the family members as the trustees. The family members themselves will contribute to the trust. and use the income from that money for the maintenance of that place of worship. So initially, when it is started, it's a private trust. Later on, since it is on the approach road, the passers-by, the people who move that side, also get associated with this place of worship, and they start getting the benefit of this place of worship. They also contribute, and slowly it gets enlarged into a place of public worship. And the trust also is expanded by bringing public people from the public at the trustees. It becomes a public religious trust. But please be careful. Exemptions in section 11 is applicable only to a public religious trust. If it is for a family, if it is for a close-knit people, then the exemption is not available. Exemption is not available for a private religious trust. Exemption can be claimed only in respect of a public religious trust. Sir, how are you saying this? What is the authority? The authority is given in the next bullet point. Refer section 13(1)(a). 13, I told you, is a denial of exemption. Exemption is denied in certain cases. And see the first one there, 13(1)(a). No exemption can be claimed for any part of the income from property held for private religious purpose. If it is for a private religious purpose, that trust cannot claim the exemption. If it is for the public at large, even for a religious purpose, it is exempt. But it cannot be for a particular religious community. We'll come to it later. But for the time being, if it is for a private religious purpose, you cannot claim the exemption. Now we'll come to the registration. So if you go back to the first slide where I said 6 aspects. How many aspects have I covered now? I have covered objects must be charitable or religious purpose. Definition, 2 aspects I've covered. Now I am on the 3rd part of registration. Let me quickly run through registration. See, whenever you talk about registration, not only under this law, not only on the charitable trust, any legislation, if you are talking about registration, you must raise 3 W's. What are the 3 W's? To whom you have to make an application for registration, when you should make an application, when you should make an application, and third one is within what time, in what form you have to make an application. 3 W's. To whom you have to make an application, when you have to make an application, and in what form. See here, all the 3 questions are answered. It should be submitted to the Principal Commissioner of Income Tax. When I say PCIT, Principal Commissioner of Income Tax or the Commissioner of Income Tax. Why they say Principal Commissioner or Commissioner of Income Tax? In certain cities in our country, Principal Commissioner of Income Tax will be there. Many parts of the country, there will not be a Principal Commissioner of Income Tax. Then you have to make an application to CIT. Wherever Principal Commissioner of Income Tax is not available, you go to CIT. Otherwise, you can come to Principal Commissioner of ECI. The form can be submitted at any time. This is very unique for this particular registration. The Income Tax Act has not said that you should make an application within 2 months of formation, 6 months of formation, 1 year of formation. They have not said like that. It was there earlier. It created confusion. Therefore, they have done away with all those things, and they have now said you could make an application at any time. But the problem here is, if an application is made 2 years after the formation of the trust, the exemption can be claimed is applicable only from the year in which the application is made and the registration is granted. The registration can be granted only from the year in which the application is made. Earlier years, you will not be eligible for the registration. That is what is important. So just to give you an example, if a trust is formed, say today, Today is 19th of January 2021, or you take 19th January 20 to make it really applicable. 19th January 20. Then from 19th January 20 to March 20, I have not made an application. 31st March 20, I have not made an application. I make an application in September 20. We make an application September. The commissioner can grant me registration from April 20 to March 21, but he cannot grant me registration for the broken period, that is part of the year up to March 20. He cannot do that. And the application must be in the prescribed form 10A. So 3 Ws to whom you have to submit, when there is no time limit, but you can get registration only from the year in which you make an application. Application must be in the prescribed form 10A. Then what is the process? Once you make the application, what's the process? The principal commissioner, Commissioner of Income Tax, will call for documents, information to satisfy himself as regards genuineness of activities. As regards genuineness of activities. We'll take an example here. What is this genuineness of activities? Genuineness of activities is the trust was formed somewhere in April 19. And then application is made in December 19, same year. April 19 is formed, December 19 application is made. The principal commissioner calls for information. Okay, from April 19 to December 19, please tell me how much have you collected by way of contributions, donations. They say we have collected about, say, 8 crores, sir. 8 crores of money they have collected. And then the commissioner asked them the question, 8 crores, what are the charitable activities you have done during this, out of this 8 crores? How have you applied these 8 crores? Then the trustees give an account for it. They give an account, and the account reflects that substantial part of 8 crores is spent for salaries, rent, electricity, vehicles for the people to move around, some high-end vehicles, and only a very small percentage is used for charitable activities, is applied for charitable purposes. Now, once the commissioner, principal commissioner sees this, somewhere he has to be alert, and he says, I am now very confident about the genuineness of the activities. You collect 8 crores and take 7.5 crores towards administrative expenses, and not even a few lakhs of rupees is spent for charitable activities, the objects of the trust. I have some serious doubts about the genuineness of the activities. On this ground, he could reject the registration. He could refuse the registration. Now, the second part, you will note, I have printed it in red color. This is what I meant. When you're talking about registration, other things are, you must know. When you come to this part, you must give a little more importance, because it was introduced by the Finance Act 2019. Finance Act 2018. Before giving the registration, the principal commissioner will look into whether the institution has complied with any other law material for achieving its objects. In our country, none of us know how many legislations are there. We are not too sure the number of legislations which are there in the country. So somebody forms a charitable activity, it's a trust, and they want to do a particular type of charitable activity. We do not know. There could be a law which says that to do that charitable activity, you need some permission of some authority. You need to have, for example, adoption of children. If you want to adopt a child, it's not so easy. There's an elaborate procedure for it. And if that is the case, compliance, if you want to help people to adopt children, then there are certain laws which you have to comply. So before giving the registration, if the income tax department wants to satisfy themselves whether the other laws have been complied with or not, which is material for achieving its objects, they will say, yes, you get that approval first, then we'll give you registration. Because what will happen? If the trust starts collecting money and subsequently to get the permission of that authority takes 3 years, the trust cannot spend the money. And if it cannot spend the money, as I told you, they want to see that the money is spent for charitable activities within a stipulated time. The objective will be defeated. Therefore, the commissioner could ask this. This is very significant of compliance of any other law, which is material for achieving its objects. See, the lengthy section, I have tried to put it in parts, that's all. PACT, that the principal commissioner or the commissioner of income tax can pass orders granting or refusing the registration. If he is satisfied, he will give the approval. He'll give the registration, grant the registration. If he is not satisfied, he could refuse the registration. And once he refuses the registration in our country, we have got the opportunity to the assessee and institution to file an appeal. When you say file an appeal, to whom he could file an appeal? He could file an appeal directly to the income tax appellate tribunal. See, the first level of appeal, after the officer passes the order, you could file an appeal to the CIT appeals. If the CIT appeals also gives an order in favor of the department and against the assessee could go to the tribunal. So this tribunal is the second appellate authority. But in this case, once the commissioner refuses the registration, they ask you directly to go to tribunal. They don't permit you to go to CIT appeals. Because a general rule which you could remember and apply this logic in some other provision also. Who is passing the order now, refusing the registration? What is the rank? What is the seniority? He is a commissioner of income tax or the principal commissioner of income tax. And if you go to CIT appeals, who is the same rank or maybe sometimes junior rank also, and if he is going to say what the commissioner, senior officer has said is not correct, which is not acceptable. Therefore, they say you could go directly to the tribunal. Now, continuing, very important, very happy to share with you the discipline from the department angle. The commissioner has to pass the order, either refusing or granting registration within 6 months from the end of the month in which the application was submitted. Within 6 months from the end of the month in which the application is submitted, you get this point? So, definitely, just like they are asking us to file the return within a time, they are also committing that they will pass the order within 6 months. They have to. But if they don't pass the order within 6 months, what is there? Act is silent. Act is not said anything. That is why the matter had gone up to the Supreme Court. And the Supreme Court, in a case which I have given there, CIT versus Society for Promotion of Education, which is there in the institute material, the trust is deemed to be registered. If they don't refuse the registration or they within 6 months, then the registration is deemed to have been granted. Supreme Court has said this. See, I put this in red. When you are glancing through the sites later on, revision, when you see the Supreme Court judgment in red color, stop for a while there. What is the judgment? Think over. Then talk about if the trust is not registered, registration is not refused within 6 months. Then it's automatically, that is the judgment. And you have to go for fresh registration within 30 days. And again, the commissioner has got the power to refuse or grant. If he grants, you are happy. If you refuse, you can go on appeal to the tribunal. Last aspect of registration is cancellation of registration. Registration is granted. And initially, the trust was complying with all the regulations. Slowly, what happened? They started diluting the compliance standards. Now they are not doing charitable activities. Then the principal can cancel the registration when they find that trust is not carrying on genuine activities or not complied with other provisions of any other law. That's again Finance Act 2019. Finance Act 2019, which I have put in red color. So the commissioner can cancel the registration. If they cancel the registration, then you got the right of appeal to the tribunal. So Now, what happens here? This any questions up to this stage? I think I covered all the questions. Again, Sumit has asked me a question. Only income above 20% of the total income will be charged to tax. Now, you see, once you cross that 20% limit, the entire exemption for the trust for that year will lose the exemption. So whatever may be the income of the trust will be chargeable to tax. It is not only that income will be chargeable to tax. So I've answered Sumit Jain's question also. And now we complete the registration. Well, if the application for registration is made in a year subsequent to the year of formation, as I told earlier, the registration granted will apply to the earlier years. Okay. See, the trust was formed in April 19 or April 18. April 18 to March 19, I have not applied. I applied it next year. Registration is granted from 1920 onwards. Then the registration can be extended to the earlier year if the objects for the earlier year also was the same. If the objects are the same, then you could apply it to the earlier years. This a sort of a facility they extend. After all, the trust in the subsequent year was granted registration. Earlier years also they were carrying on the same objects. They could continue, provided third bullet point. This benefit is not available if the registration for the earlier years is either refused or cancelled. Suppose in earlier years you applied and they refused, or it has been cancelled, then you cannot take recourse under this benefit. So that's about the registration part of it. And with this, we complete the third element. Objects must be charitable. What is the definition of charitable purpose? Third element is registration. Out of 13 elements, we have covered 3, and we are now entering into the 4th. What are the components of income? Now, I'll put a question. Those of you who want to answer me in the form of a observation in the chat box, I'll be happy to see your answer. How many of you find it difficult to remember all aspects of direct taxes provisions? There are so many sections, 298 sections, and so many subclauses, and the syllabus now question paper covers almost all chapters. Do you find it difficult to remember all these things? This is my question. If anybody wants to answer this question, just type out a short answer. Yes, I find it difficult. I find it easy to remember all the sections. I know I could get only one answer. You could put that answer on this chat box. I'll be eager to know that. My own presumption is people find it extremely difficult. Not only for the best of student also, it's very difficult. So why you want to overload your already overloaded memory? So what are the components? Just visualize what type of income a trust will get. Somebody would have given a property to the trust. So they may get some rental income from the property. That is one thing. Second thing, somebody would have given a business to a trust, and the trust will carry on that business. They'll get business income. Third thing is, the money which they get out of these activities, they would have invested somewhere, they will get some interest income, other sources income. And fourth one, more important, is the donations which they collect, voluntary contributions they collect. Voluntary contributions also is income. So components of income of this type, these various components of income, which voluntary contributions. What is the next one? This one I will explain, but I will income from property, income from business, incidental to objects, capital gains on transfer of assets. So only thing which has to be explained is the second part of it. Second part of it. What's the second part? Second bullet point. I'm reading it out for you. Benefit to specified persons given by institutions operating a hospital or a medical institution or any education institution. Remember this very carefully. This benefit, this clause, this particular point is applicable not to all charitable institutions, but only to an institution which is operating a hospital or education institution. If other charitable institutions are going to give a benefit to a specified person, the trust will lose its exemption. Entire income will be chargeable to tax. They cannot give a benefit to a specified person. They cannot give a benefit to a specified person means the trustees, the relatives of the trustees, the author, the relatives of the author, any concern in which the relatives or the directors or the trustees are interested. So if any other charitable trust other than hospital or medical institution or education institution gives a benefit to a specified person, the trust itself will lose the exemption. But if a benefit is given to a specified person by a hospital or an education institution, the trust will continue to get the exemption, but the benefit which is given to the specified person will be evaluated and taxed in the hands of the trust. Whatever benefit they give to a specified person. So this is very important and very practical also. I'll give you an example. If a charitable trust is operating a hospital, good hospital, and they give good service to the poor people, they are helping a lot of people. It's genuinely a charitable trust. But what happens is one of the trustees' close relative, is traveling by car near the hospital and meets with an accident very near the hospital. And he is rushed to the nearest hospital, which is this hospital, given treatment there. And if he's given treatment, for others, outsiders, if they are charging 100 rupees, for this gentleman being a trustee's relative, they charge him 80 rupees. So a benefit is given to a specified person just because they acted with humanitarian condition or mind. Should they lose the exemption? At the same time, they're given a benefit to a specific person. So they say you should not deny the benefit to the institution, but that benefit which is given to the specific person should be evaluated and added to the income of the charitable trust. So these are the components of income. Voluntary contributions. Second, of course, corpus contributions are exempted. If the trust is registered, maintains books, so everything, audit, all these things, the capital corpus will be exempted. So these are the components of income. With this, we complete the fifth part or the fourth part, I think. And now we come to one more thing, and then we'll go for a break. Application of income. I told you the Income Tax Act wants to see the charitable trust spends the money within a specified time, within a specified period. So they say this one, 85% of the income must be applied in the previous year for charitable or religious purposes. If the income is 1 crore, 85%, 85 lakhs should be spent for charitable activities or religious purposes during the year. During the year, they have to definitely send it. That is the condition which they stipulated for claiming the exemption. And they have clarified, for this purpose, for calculating this 85%, income will include voluntary contributions received. So even the voluntary contribution, 85% you have to spend. Other than, very important, other than corpus contribution. Because corpus contribution, they cannot spend. The mandate given by the donor is that you keep it, don't spend it. And if the Income Tax Act says spend it, there's a conflict. Therefore, the explanation to section 11(1), clause 1 says that for this purpose, voluntary contributions will not include corpus contribution, naturally. So 85% of the income they should apply. That means, implication is that they could retain 15%. Out of 1 crore, 85% they spend, 85 lakhs they spend, 15 lakhs they could retain. And they could retain it without any time frame. Very important. It's not necessary this 15% they should spend within 2 years, 3 years, something like that. Nothing. They could continue. There's no time period for within which this 15% should be. 15% is a sort of a bucket given to them to carry over. Retention of 15% of the income. So that is a very important one, which we have explained. Now coming to, again, red I put. When I say 85% should be spent and 15% can be retained, what they talk about gross receipts or net income. That's what is important. I'll give you an example, simple example. I will take that, let's say 10 crore, 1 crore receipt. Gross receipts is 1 crore. There are expenses for running the trust. Say 5 lakhs is the expenses for salary, electricity, telephone charges, postage, all these expenses, 5 lakhs. Out of 1 crore, 5 lakhs goes off. Expenses. 95 lakhs. Now, you could retain 15% of 95 lakhs or 15% of 1 crore. That's the question. That is the question which is asked. The department said in one of these situations, you could retain 15% of 95 lakhs net amount after the expenses. The assessee said no, 15% of 1 crore. This matter went up to Supreme Court. That's why another Supreme Court judgment. Whatever I selected and whatever is referred in the institute material, most of them are Supreme Court judgments. In some cases, they are referred to High Court also. Supreme Court in CIT versus Program of Community Organization has held that 15% of the gross receipts you could retain and 85% of the gross receipts you have to spend. Okay, this is 15% retention to the extent of the gross receipts, on the gross receipts. This is a decision by the Supreme Court which you could quote. This is important and very, very significant. This benefit is not applicable for international application. If you go to that earlier slide, yes. If you go to the earlier slide, you will find that charitable trusts which are doing international activities, they could get exemption only if the income is applied for charitable trusts. If they don't apply, they will not get. So this benefit of retention of 15% is not applicable for charitable trust which is involved in international application. Anyhow, less important, I will not spend time on it. At this time, we could take a break, but there are 2 questions which have been put, one by Padmanabhan, another by Raman Sachdev. Padmanabhan is asking the question, interest income from corpus will be included in 85%? Interest income from corpus. Yes, if you have interest income is also the income of a charitable trust. So if you get interest income, 85% of interest income also you should spend. If you are not spending that 85% of the interest income, then to the extent you are not spent, you will not get the exemption. So to answer his question specifically, whether the interest income from corpus will be included in 85%, answer is yes. Unless the trust makes a specific application for permission. That will come later. For the time being, the answer to your question is the interest on that corpus also you have to spend, unless the donor has given a further mandate saying that the interest also you accumulate for 5 years, 6 years, and then spend it. Because I have known some donors. This is a practical case I'm discussing with you arising out of this question. I did not have a plan to discuss this. Because Padmanabhan asked me the question, I'm clarifying it for you. A gentleman who lived in one part of India, grew up in that particular place, developed an affection to that particular place. His school days, college days, and early career, he was there. So much of attachment to that locality. He moved to a foreign country and amassed a lot of wealth. Now he is 60 plus. He has got huge funds. And he says that fund, he wants a trust to take care of it, and he will contribute a bulk amount. He will contribute a bulk amount, and he's giving a mandate, very clear, lengthy mandate is giving. He's giving some huge amount and saying that I want you to keep this money with you, and the interest on this money you accumulate and use it for education of weaker sections of the society. Uh, in different schools, pay the school fees directly to the schools, don't give it to the children or children parents. So he says you accumulate this money and use it for the next 10 years. If they are giving such detailed mandate to the trustees and the trustees accept that responsibility, then possibly his question could have some relevance. Interest also will be accumulated and need not be spent because of the mandate. If they give only for the corpus, you should not, amount given they should not spend, then the interest arising out of the corpus you should spend. So there is no straightjacket answer for his question. Depends upon the mandate. Raman Sachdev says, sir, voluntary contribution is income from other sources? Yes, it will be income from other sources and it will be chargeable to tax. If it voluntary, but of course, if you spend 85%, it is exempted. If you don't spend only, it is chargeable to tax. Okay. Having finished this part of it, deemed application, we will take a break now. We will take a break for, normally how much is the break? We take a break for 8 to 10 minutes. We take a break for 8 to 10 minutes. It is now 7:37 in my watch. By 7:45, we will reassemble and continue. Thank you, and we'll continue with the remaining part of the slide presentation immediately after the break. Thank you. Yes, now we come to deemed application. I explained to you that there are practical circumstances where we cannot. It comes. Uh, Deemed application is 85% of the income not applied for charitable religious purpose during year. There could be some practical circumstances where a trust is unable to apply it for charitable purposes during the year. What could be that? The first one is case one, income not received in the previous year. A trust has got some investments. Say corpus contribution, it has put it in investment. The interest on that investment, the trust has not yet received the interest, but accounted for the interest on accrual basis. The trust has passed an entry, interest receivable account debtor to interest received. Now, assuming the interest receivable is say 50 lakhs. Now, 85% of 50 lakhs they have to spend. But they have not received the income. How could they spend when they have not received the income? So that is first situation. Income not received in the previous year. Second situation. Beautiful. They have not said anything. They said for any other reason. They are unable to visualize. Omnibus, generic, any other reason. What is that any other reason? Supposing a charitable trust, the cashier is there in the office, and one philanthropist walks into the charitable trust office on 25th of March 2021. 25th March 2020. 25th March 2020, before the announcement of the lockdown, and gives a check for 1 crore donation. Have it with you. Use it for charitable objects. It's not a corpus contribution. It just gives you as a regular contribution. By the check is cleared and credited, it will take 1 or 2 days. 26th March only it is credited. Now, 85% of 1 crore, 85 lakhs, they have to spend before the end of the year, 31st March 2020. Between 26th March to 31st March, 5 days, they have to spend 85% of 1 crore. Is it possible? Spending also becomes difficult. Spending for charitable purposes. So that could fall under any other reason. Like that, any other difficult situation. For example, COVID, the pandemic, is any other situation. So income not received in the previous year is case one. For any other reason should be case two. There was a situation where the company the charitable trust had planned for a charitable event in a particular day at the end of say 20th or 25th of March. They have planned an activity, fairly big activity, charitable activity, and somebody Shanmugam is writing whether corpus which is meant for specific purpose should be also be kept in a yes. I'll come to that. Shanmugam, I'll come to your question little while from now. For any other reason, is it's case two. I was beginning to talk about something else. It escaped my attention. Anyhow, case one and case two. Now, this will be treated as application and has to be applied in case one either in the previous year on receipt of the immediately following previous year. See, supposing you fall under exception number one, case one, you are not able to spend because of non-receipt of income. It will be treated as application and has to be applied when? It has to be applied either in the previous year of receipt. Supposing you receive next year, you have to spend it that year. Or if you receive it next year also, it's not necessary you should spend 85% that amount in that year. You could spend it in the immediately following previous year. Why they are telling that is, supposing you receive it in the fag end of that year. Again, you cannot spend it. Therefore, they said either in the year of receipt or in the immediately following previous year. If you fall under case 1. If you fall under case 2, it has to be applied in the immediately following previous year. If you fall under case 2, you must spend it in the immediately following previous year. That is the requirement. So these two is deemed application. And it is not automatic. It's not automatic because application has to be submitted in form number 9A to the assessing officer before the due date for filing of return under 139(1). If you are not able to spend for this reason, for non-receipt of income or for any other reason, then you have to make an application to the income tax officer, assessing officer, and tell in form number 9A, yes, I have not received this income, therefore I am not able to spend it. This has not, for any other reason I am not able to spend, so I am going to accumulate. So this you have to do it. And mind you, due date for filing of return, Finance Act 2020 has extended the due date for filing of return from 30th September to 31st October. Of course, 31st October for this year was further extended because of the COVID. But in the Act itself, from 30th September, they have made it 31st October, which you should have in mind. Having finished that, application has to be submitted, and this is how it. Now, supposing in the for calculating, this is deemed as application of the earlier year. You spend it in the next year. The amount which you spend it next year will not be considered as an application for that year, because this is an accumulation of the earlier year which you are spending in the next year. So you cannot take this as part of your computation for the calculating 85% of the income of the next year. That income, whatever you get, 85% you should spend separately. That is an important point which you have done. And this benefit is not applicable to international application. International application, you should spend, to the extent you spend, you get the exemption. Balance of income will be chargeable to tax. Impact if not applied. See, you accumulated. And you say, as and when I receive it, in the year of receipt I will spend, or in the immediately following previous year I will spend. You have given an assurance like that, and later on you don't do it. Impact if not applied. Section 11(1)(b) gives the answer. Case 1, it will be treated as the income of the previous year immediately following year of receipt. So they will wait for the next year to be over, and it will be treated as income of that year. Again, mind you, I have not quoted this case law, but this matter has gone up to the High Court. If I remember correct, it's Delhi High Court which has given the decision. It says that if it is treated as income also, treat as income, okay? And 85% of that you spend it. You spend this amount and the 85%. If you spend it in that year, there's no problem. If you don't spend it, then it will be treated as income of that year and it will be charged to tax. So that is what you should remember. And case 2, if you fall under case 2, it will be income of the previous year immediately following the year in which the income was derived. Suppose it is derived in March 19, it should be treated as income and you should spend it before March 20. If you don't spend it before March 20, it will be treated as income of the year ended March 20. So that is an important thing which you should remember in case of impact. So this is Ashutosh Panda has asked a question from Katak. Sir, the details of accumulation is also to be given in Form 10? No. See, this is not accumulation. Panda and others, please note, whatever term which I used here is deemed application of income. I am not talking about accumulation. Accumulation, I'm going to come later. Accumulation is different. Deemed application is different. Deemed application, you can come only under these two categories. One, income not received in the previous year or for any other reason. But accumulation is different. I'll explain to you, then you'll know the difference between application and accumulation. Accumulation, what he says is Form 10. That is correct. But for a deemed application, it is Form 9A. Having finished that, Now we'll come to application of income. Okay, this is also very important. I will take 2 minutes of your time. Any section, you understand the background, you understand the objective, then you will remember it for a longer period. You will never forget it. Contributions towards corpus of a registered charitable institution or 1023C institution will not be considered as application. Explanation to section 11.1. See, what happened in some cases? Trust got some income. It's got some income. And it had to spend 85%. It had to spend 85% to get the exemption. It's not able to spend. So what it will do, it will identify another registered charitable institution, and it will contribute towards the corpus of the charitable institution. It will not contribute as a regular contribution. It will contribute as a corpus to the another registered charitable institution. Now, if it contributes as a corpus, what happens is, whatever is the 85% they are contributing, it's not spent, it is accumulated as a corpus. That means the donor who gave the money that it should be used for charitable activities during the year, you are contributing to another charitable trust and treating it as a corpus, and they are not going to spend it for the next 3-4 years. Therefore, the purpose, it gets delayed. I told you they don't want to delay the process of reaching the ultimate beneficiaries. So if you contribute to the corpus, if you contribute generally as a regular contribution, it's okay. They have to spend during the year. They will spend during the year. But if you are going to contribute to the corpus, then they say it is not treated as an application. And if it is not treated as an application, you are not spent 85% of the income. If you are not spent 85% of the application, the income will be charged to tax. Okay, so that is what is the point which you have to remember. Now, what is important is, I said corpus of registered charitable religious institution. Registered charitable institution, I put it in ordinary black letter. But 1023C institution, I have put it in red color. That means this contribution towards the corpus of this 1023C institutions was added by the Finance Act 2020. 2020. It was not there earlier to that. They missed it out. And then they added it. Okay? So you have to be careful. So since it is a Finance Act 2020 amendment, only the 1023 institutions I have put in red, and corpus, because if you contribute to the corpus, to identify that, I have taken a different color. So this is what you should not do. If you contribute to corpus, then it will not be considered as an application for the purpose of calculating that 85%. The disallowance provisions as regards TDS and payments otherwise than by banking channels is applicable in respect of application of income. See, charitable trust may have some employees. If they have some employees, they have to pay salary to them. If they pay some salary, some of the salaries would attract TDS. They have to deduct tax and remit it to the government. If they don't deduct tax at source, or after deducting they don't remit the tax at source, in addition to the penalty under the TDS chapter for not deducting, for not payment, the expenditure which they incurred will be disallowed. The expenditure will be disallowed because any expenditure which is subject to TDS, tax has to be deducted and remitted. If they don't do it, the expenditure will be disallowed. The same provisions is applicable in respect of the application of income by a charitable trust. Not only that, that 40A3 and 40A3A, what is that? If you are incurring some expenditure, you should incur that expenditure through a banking channel. That is through the electronic mode or by a cross check or a cross draft. You cannot do it by bearer check or by cash. If you do it, 30% of the expenditure will be disallowed. That is equally applicable to the application, disallowance portion, to the charitable trust. Whatever income they apply for charitable purposes, that also it should be done only through banking channels. If you through by other than banking channel, 48.3 and 48.3a will apply. This is another aspect which you have to know. Now we come to now this is where Ashutosh Panda's question will come into place. Now, if you go back to the slides which I gave you, the elements, different elements, 13 elements I told you, no, I have finished up to application of income, deemed application. 6 items I have covered. Now the seventh segment, seventh aspect of it, accumulation or setting apart of income. Okay. Now that is the seventh element which I come here. Now is the PPT visible? Shanmugam, you have to answer me. Is my PPT visible now? Your written PPT is not visible. I'm sorry for that. It's not coming on the screen. Is it coming now? Okay, sorry. You want to see the previous slide? A deemed application, 85% of the income not applied for charitable register during previous year. Reasons, case 1, case 2. Contribution towards corpus of registered charitable religious institution and 1023C institution will not be considered as application. Okay. This I have explained to you. Now I come to accumulation of income. 85% of income not applied or deemed to have been applied during the previous year. Okay. See, what happens is a trust is planning to implement a capital project, a big project. What's a big project? The charitable trust wants to construct a hospital for the weaker section of the society. Genuinely, they want to construct. Now, if they are going to accumulate at the rate of 15% of their collections each year, by the time they accumulate the income, the cost of starting a hospital will go up and they will never accomplish their dream. Therefore, they could make an application to the assessing officer and tell the assessing officer, sir, kindly permit me to accumulate more than 15% of my income. I want to accumulate 50% of my income. I want to accumulate for what purpose? I want to accumulate it for the purpose of completing a hospital project. If I don't accumulate that way, I cannot complete the hospital project. They will come and give statistics. So in this area, so many people are living and they require medical attention and they are all weaker sections of the society. I got the statistics, about 5,000 people are there. So they need medical attention. They go to a nearby hospital where they have to pay a higher amount. They are not able to afford that facility. Therefore, I want to construct. Now, if I'm going to accumulate at the rate of 15%, another 10 years, I cannot construct a hospital. So they give reasons for this and the officer is convinced, the officer can give permission to accumulate more than 15%. It's not because they have not received the income. It is not because of any other reason, but they want to accumulate for a specific project. Then what say Ashutosh Panda said, this accumulation for a specific charitable activity, okay, you have to make an application in Form 10. The deemed application, you have to do it in Form 9A. The accumulation of income, you have to do it in Form 10. And this also you have to do before the due date for filing of return. That's also there. Now we have a problem here. The problem is, when you make an application in Form 10, whether you should give details of a specific project, like I said, hospital, give a details. Or you could only say, I want to accumulate 50% of income for the objects of the trust. Here we have a controversy. That's why I put it in red color. There is a decision of the Delhi High Court. Delhi High Court in Bharat Krishak Samaj versus Deputy Director of Income Tax, holding the view that a generic application is sufficient. Saying that, of course, the SSC had to go up to the High Court to win this case. And we do not know whether the department has left it with this and they has gone to the Supreme Court, or they accepted this decision. So we have to wait and see. So in practice, if somebody comes to me and tells, sir, I want to accumulate my income, I will suggest to him, my advice to him would be, give the details of the project. Because in Form number 10, what Panda referred, in Form number 10, there is a specific question, give the details of the project. If you're not giving the details of the project and just say objects of the trust, to convince the officer for permission becomes difficult. And if he denies it, then what happens is you have to file an appeal and win the case. It will take a long time. If somebody has committed this mistake and come to us, we'll make use of this case law and win the case. But if somebody is, before doing it, comes to us, we'll suggest them not to get into this legal controversy. But from the examination point of view, if you are writing an answer, you could very well write the answer. Sir, there is a decision of the Delhi High Court that the application need not be specific. The application could be, I want to accumulate 50% of my income for fulfilling the objects of trust. That should be sufficient. And that again, I put in red color. When you are revising it, when you come to the Delhi High Court, this aspect, you could try to visualize this aspect. This is very important. This is accumulation. Now we will come to application has to be made on or before due date for filing of return under 139. And one more important aspect, AO can give you maximum 5 years time period for which they stay. Okay, 5 years time. He cannot, earlier there was no time frame at all. Some years back, they introduced this 5 years time. So even if you are constructing a hospital or a school or a community center or anything you want to do, you have to do it within 5 years. Maximum time the officer can give is 5 years. And within brackets, I have said something. The period for which there is a stay order shall be excluded. Supposing you want to construct a school in a particular area and you applied for plan and all, the work is progressing, but the neighbors around there raise an objection. They file a case in a court saying that if a school comes, too much of traffic in our place, we will all get affected, so we don't want the school to come. So they file a case and the court passes a stay order. So 3 years goes off in the stay order. Out of 5 years, 3 years goes means within balance 2 years, they cannot complete the hospital project. So what happens is a school or hospital project, the time during which the stay is in shall be excluded. Stay order is in force shall be excluded. Very practical suggestion there. Application can be made to the AO for revision of objects. However, time cannot be extended beyond 5 years. See, this is again a practical thing. Initially, when I made my application in Form 10, I said, I want to construct a hospital. Officer also gave me permission. Yes, you can accumulate 50% of your income for the purpose of the hospital. I give you 5 years time to complete the hospital. After 1 or 2 years, the 2 years, the charitable trust again goes to the officer and tells, sir, initially you gave me permission for 5 years to construct a hospital, but today I want to change. I want to change over to school rather than hospital. The, the officer will ask, why? What's the reason? Then he gives a good reason. The charitable trust gives a reason. Sir, when I started the hospital, when I made an application for hospital, there was no hospital in that particular area. So I sought permission. But before I could get my plan sanctioned and start the activities, there is another charitable institution which has started a charitable trust within that area, and they have already started functioning. So if I start one more, it will be a duplication of the effort, and it's not going to serve the purpose. Hence, I want to complete a change it over a school, which will be more beneficial for the people living in that area. Logical. The officer can grant you time, but the problem is 5 years is total. Out of 5 years, 2 years are already over. So the officer can give you the remaining 3 years time to complete the school project. He cannot give you 5 years time from the time you make a second application. Maximum 5 years from the original application. That is the time frame which is given in 11(2) of the Income Tax Act. Accumulation must be invested in investment specified in 11(5). I think somebody asked this question earlier. Somebody asked this question whether the accumulation should be invested in specified investments. The accumulations must be invested in specified investments in 11(5) of the Income Tax Act. They don't want you to go and speculate in some listed shares or real estate company. They don't want you to do that. They want the money to stay. If you see my initial introduction, I told you 4 aspects. One is charitable objects. Second is time period. Third is the safety of the money. The money should be kept safely. So accumulations must be invested in investments specified in 11(5), where they list out most of them government securities. So this is accumulation of income. With this, we complete 7 items, 7 aspects. Now again here, this aspect is again red color. Immediately it will attract your attention. Contributions from the accumulations to registered charitable religious institutions and Section 1023 institution shall not be treated as application. This I am not telling because Finance Act 19 or Finance Act 2020. I am just telling it because it is important. That's why I have put in red color. Contributions from the accumulations to registered charitable. You see, you accumulated, and what will happen is at the end of the 5th year, the officer has given you 5 years time to construct a school, hospital, or whatever you asked for. And then 5 years you have not done anything. Then it will be treated as income of the 5th year. And if it is treated as income of 5th year, you will contribute to another charitable trust. It says 85% of it should be spent. So 85% you will contribute to another charitable trust. And that trust will take another 1 year to spend it. Therefore, there they have said, any contribution out of the accumulation, if you make any contribution to a registered charitable religious trust or 1023C institution, shall not be treated as an application. Mind you, there's a difference between the earlier clause and this one. I will take you back. Just wait for a minute because I have to take you back like this only. Yes, here. Contribution, what? What's the important word there? Contributions towards corpus of a registered religious institution and 1023 institution will not be considered as application. Only if you, out of the current year income, if you contribute to the corpus, it will not be eligible. But here, if you contribute any contribution, I have not qualified it by saying corpus contribution. I am simply saying contributions from accumulations to registered charitable religion and 1023 institutions shall not be treated as an application. because you accumulate for a specific purpose, and then you contribute to another charitable institution. They will take a few more years to spend it. Delay happens. They want to avoid the delay, so they will not treat it as an application. If they not treat it as an application, it will be they have not spent 85%. Then it will be chargeable to tax. That's what you have to remember. Now we will come to the next element, ninth element. Or eighth element is there, specified modes of investment. I don't have anything to tell, but to list out the 11.5 investments. That is very mundane thing. That's you could refer to 11.5 and find out what are the specified investments. I have nothing to explain there, therefore I have not put it on the screen. Ninth one is computation of income. How to compute income? Valuation of benefit. Are you able to recognize this benefit is chargeable to tax in the hands of the trust? Only to which type of trust I told you? Can you recollect? Only to a trust which is carrying on a hospital or education institution, gives a benefit to a specified person. Only that type of institution. For other institutions, if they give a benefit, then the benefits, the exemption itself is denied for them. So, but if it is an education or a hospital, then the benefit, value of the benefit will be chargeable to tax. Okay. Income from property, how to value that benefit? How to value that benefit? I'll give you an example. Normal transfer pricing rules, arm's length price will come. If you have given that service to an outsider who is not a specified person, okay? If you have charged him, you would have charged him 10,000 rupees. But to a specified person, you give a concession, charge him at 8,000 rupees. Then that 2,000 rupees will be benefit, and it will be included in the income. Income from property as per provisions of income tax law. Just like you compute income from host property, rental income, the chapter 22 to 27 of the Income Tax Act will apply. Compute the income as per that chapter. Okay. Income from business incidental to the objects. Here we have to spend some time and see two bullet points are coming in red color. Income from business incidental to the objects, separate books must be maintained. Separate books must be maintained. Regular computation, just like you do 28 to 43, regular computation you do the business profits. Whatever is the business income provision chapters, you apply that and compute the business income. But one thing, denial of depreciation. Depreciation is not allowed. If the purchase of asset is considered as application. Denial of depreciation if the purchase of asset is considered as application. What does it mean? See, the expenditure which you incur can be capital expenditure also. Application of the income for charitable, you could buy a machinery also. You could buy an asset, furniture. The entire cost of the furniture is treated as an application. And then you say the furniture used for business, you want to claim depreciation on the furniture, it will tantamount to claiming the cost twice. Once in the form of application and the second in the form of depreciation while computing business profits. Therefore, the law is very specific. The depreciation is not allowed, okay, if the purchase of asset is considered as application. If the purchase of asset is not considered as application, then you could treat it as you can claim depreciation. If it is considered as application, then you are denied depreciation. Okay, this is second point. Well, very important point which you have to note. That's why I put it red color. In fact, prior to the introduction, this particular point in this section, what happened was the matter went up to the courts. And the courts held, in the absence of any specific provision, denial of depreciation is not correct. The officer has to give depreciation. That was the verdict in the court. Subsequent to the decision of the court, the act was amended and they put a clause saying that while computing business profits, 11.4a, 11.4, 11.4a, both the sections, that if you are going to use this for the benefit of purchase of the asset is treated as an application, you cannot claim depreciation on that. One more important aspect is you file a return for a charitable trust and the charitable trust has got a business income. You computed the business income. Okay. The officer takes it for scrutiny, regular assessment. And when the officer takes it for regular assessment, he increases your income of the business. How? Two methods. One, by disallowing certain expenditure. He says the expenditure is not backed by proper vouchers, or the expenditure by application of certain provisions of the Income Tax Act, the expenditure is disallowed. So he adds the income. Second aspect where he could disallow, certain amount which the trust collected is suppressed. They are not shown it as income at all. If they are not shown it as income, they are not applied it also. At the time of assessment, the officer finds out that certain income is not shown. Charitable trust had another bank account. The collections in the bank account, they are not brought into the accounts at all. Something like this has happened. The officer finds it out and adds it to the income of the trust because it's concealment of a revenue. The two ways he could add the income. Now what happens is, the section says additions made by the officer at the time of assessment will not be eligible for exemption. The Act has not distinguished between additions made by disallowance expenditure, additions made by suppression of revenue. The Act has not made any distinction. But the matter has gone to the court. I have not put it in my slide. You check the institute material whether this case law is got, or next class, day after tomorrow, I'll give you the reference of that case. But there is a case. If the income is added because of suppression of income, then it will not be entitled for the exemption. If the income is added because of disallowance under certain provisions of the income tax law, that income will not be, should be eligible for exemption. That is the reasoning or the rationale given in the judgment. I will give you the name of the case. I read it only this afternoon, so I was not able to include it in the presentation. Anyhow, I will tell it next time, share it with you next class. No exemption can be claimed under Section 10 other than Section 10(1), 1023C, and 1046. Refer 11(7). Now, while computing this income, say interest from other sources, the charitable trust has invested in government securities. 11(5)(a) government securities are permitted. Charitable trust has invested in government securities. Interest on government securities is exempted under Section 10. So they will claim exemption under Section 10. And then they will also claim the benefit of this chapter, 11, 12, 13. So this section says, this condition says that in 11(7), you cannot claim any exemption under Section 10 in respect of a charitable trust or institution registered under 12(a) and claiming exemption of this chapter. You cannot claim, excepting 3 sections. What are the 3 sections where you can claim exemption? That also only one, only agriculture income. Next bullet point will clarify for you. It says that you cannot claim exemption in Section 10 excepting 10(1). 10(1) is what? Agriculture income. Rightly so. But the trust carries on some agriculture. Somebody has given an agriculture land to the trust. The trust continues to carry on the agriculture activities, derives some agriculture income, and uses that agriculture income for charitable activities. Claims exemption 10(1). Yes, it can claim 10(1) because section says no exemption can be claimed under Section 10 other than Section 10(1). Rightly so, because 10(1) agriculture income is a state subject. Central cannot levy tax on agriculture income. Therefore, they are carving out the agriculture income. 1023C and 1046. 1046 is certain institutions notified by the government, their income will get exempted. Okay. So if you are an institution registered in 1046, then, and this chapter also, what will happen is you will try to claim both. Up to now, it was permitted, but see the next bullet point, you will remember Finance Act 2020. Finance Act 2020 proviso is added to 11.7. A proviso is added to 11.7. Once you are granted registration under 1023C, or if you are notified under 1046, then the registration given under section 12A will become inoperative. Will become inoperative. Mind you, this was introduced in Finance Act 2020. You have a multiple choice question in the final paper, direct taxes. If you have a multiple choice question paper, then this could be a very targeted area for a multiple choice question. Because up to last year, the provision was different. Current year, the provision is different. Finance Act 2020, proviso to 11.7 says registration under this 12A becomes inoperative if approved under 1023C or notified at 1046. Once you get the approval there, this will become inoperative. So either you go under those sections or come under these sections. You cannot get the best of both worlds. This is a provision which they clarify. Capital gains. I told you another how to compute capital gains. Okay. How to compute capital gains? Oh, I'm sorry. So many people are asking questions, but the page is full, so I forgot. Okay, give me some time. Okay. I think Sumant has asked a question. Period of 5 years is project wise. Okay. I could not agree with him on the project wise, but it is income in year wise. Supposing this year you want to accumulate for a hospital project. Okay. You accumulate 5 years from this year onwards. Next year, you got a substantial contribution from some philanthropist, and you want to start another project, not a hospital project, some other project, a capital project. For the next year, you make another application. For that project, from that year, you can get 5 years. So if you apply for 2 projects simultaneously in the same year, the 5-year time limit is not given for each year, but 5 year each project. 5 years is given for some of the projects. They may give less than 5 years also. 5 years is the maximum period. So the income tax officer can say, this project is not so big. Why do you need 5 years for it? I want you to complete within 3 years. Today, technological advancement, any big building is also constructed in 12 months. Why do you need 5 years? The officer could give some reasons for it. So I went back to answer Sumit's question. So that's the answer to his question. He asked a very simple question, whether the 5-year period is for project wise. Answer his question: if 2 projects, application for 2 projects are made in the same year, then 5 years should be reckoned from that year only. Normally, charitable trust should not go in for 2 projects in the same year. It's not advisable for them to go. And officer also may not be comfortable in giving permission. You have to take it in 2 years. Then 5 years will be calculated from each year onwards. And you have to do a lot of convincing. If you take 2 capital projects at the same time, it is theoretically it's fine, but practically it will be very difficult to convince the officer. Let me come back to the questions later on. When I conclude the session, I will go through the questions. If I have not answered any of the questions, it is my pleasure, because I derive satisfaction only when I answer questions. So if I missed out some question, also kindly bear with me. I'll come back. Even if I missed out some time during this presentation, I'll go through the questions and come back to you with my answer in my next session. If I miss it out, I'll try to complete it today itself. Okay. Capital gain, if is invested in another capital asset during the previous year, it will be considered as application. So if the capital gain is invested in another asset within the year, then whatever is the capital gain, it's whatever is the investment made is treated as application. But we have to be careful. It's not so simple as I put it. So I have to take some illustration for this purpose. Now, illustration, very simple illustration I have taken. See, always I believe any complex thing also try to visualize in a simple manner. The net consideration on a sale of a property, a building, it's sold for 1.5 lakhs. The cost is 1 lakh. I am taking a situation where I'm not applying the indexation, etc. Okay. It should be any asset, not necessarily a long-term asset, any capital asset. 1.5 lakhs is the cost. 1 lakh is the cost, 1.5 lakhs is the net consideration received. Investment in new asset. Case 1, 1.5 lakhs. Case 2 is 1.2 lakhs. Case 1 is the entire consideration, net consideration has been invested. Case 2, less than the net consideration is invested. Then what happens? And the asset is wholly used for charitable purposes. This is what is important. I will skip the partly part. Next slide is part. I'm not going to deal with that. The capital gain of 50,000. How much is the capital gain? 1 lakh 50 minus 1 lakh. 50,000 is treated as application because the net consideration is invested in another asset. The net consideration, the whole of the net consideration is invested in another asset. Case 2, the capital gain to the extent of the cost of new asset exceeds the cost asset transfer. Okay. To that extent, it is treated as an application. So what is the cost of new asset? 1.2 lakhs. What's the cost of asset transferred? 1 lakh. 1.2 minus 1. 20 lakhs will be treated as an application. 20 lakhs will be treated as an application. So this is if the asset is held wholly for charitable or religious purposes. If the asset is held partly, then the trust should have been created before 1462. Then only it is eligible. Otherwise, it's not eligible. So I will, for what is worth, I will give you an illustration for that also. Assets held partly for charitable or religious purposes. 2/3 of the income from the asset is held by the trust for charitable. So the person who has contributed the property has said 2/3 of the income of the asset must be held for, must be used for charitable purposes. So now I am giving you an illustration. Net consideration is 1.8, cost is 1.2, investment in new asset is 1.5. Okay. Capital gain. What is the total capital gain? Find out. 1.8 minus 1.2. Here, if you are eligible for indexation, you could do the indexation also. You are eligible because the trust should have been created before 1462. 1.8, 1.2 is 60,000 is your capital gain. 2/3 of 60,000 is treated as charitable activities. 2/3 of cost of new asset. Cost of new asset is 1.5 lakhs. 2/3 of the cost of new asset, 1 lakh. 2/3 of the cost of asset transferred. What's the cost of asset transferred? 1.2. 2/3 of that. So 1 lakh minus 80,000. 20,000 will be treated as an application. Out of 60,000 capital gain of transfer asset, 20,000 will be treated as application. But this is less important. I think you could really skip this because practically it has got very less importance. But from an examination point of view, a risk factor, if some question comes up. We come to another very important area, anonymous donations. Anonymous donation. I have deliberately gone back and removed what came on the screen. I want to tell you the objective. Why? What is anonymous donation? First, the trust or institution has collected some contribution, but they are not having the details of the person who contributed that amount. They say they have got 5 crores collection. Officer asks, from whom did you collect this 5 crores? They are unable to give the details. Sir, some person came into our office, gave us cash, we collected it. Are they transferred from bank account to our trust account? Who has transferred? What are the details? We don't know. then it becomes anonymous donation. Donor's details not available. Now what happens there? The person who has contributed this amount possibly has derived some income and not paid taxes on it, accumulated that cash, and that cash he is giving for charitable activities. That means that amount which he is contributing has not suffered tax at all. The person who has contributed has not paid a tax. And if the charitable trust also gets the money and applies it for charitable activities, and if it also gets the exemption, one limb of the transaction goes untaxed, which is not correct. And therefore they say they are not able to trace the donors. The donors may be many. They are not able to trace the donors and charge it to tax. If they are not able to trace the donors, the trust has received the money, so the trust has to pay tax. This is the objective of this anonymous donation. Now, anonymous donation, exemption 11 and 2023C denied for anonymous donation and is chargeable to tax at 30% plus surcharge and cess. You see here, if the trust is unable to give the details of the donors, whatever is the donor they collect, donation they collected, contributions they collected, will be chargeable to tax at 30% plus surcharge. Huge tax. But a big trust may collect a few thousands by way of anonymous donation. If they collect a few thousands, where should they be denied? Therefore, there's a threshold limit. Threshold limit, 5% of the total donation received or 1 lakh, whichever is higher. 5% of the total donation received or 1 lakh, whichever is higher. It's all right. Up to that level, you could collect and without the identity of the donors. Small amount. 5% of the total donation or 1 lakh, whichever is higher. Please be careful, whichever is higher. And they permit it. This is a threshold limit. Excess or threshold limit is chargeable to tax at 30% plus surcharge plus cess. Excess, so up to 5% is exempted. Okay. Now, this exemption is not applicable in respect of, again I put in red, trust institution wholly for religious purposes. Okay. You take a religious trust, public religious trust. How will they get the voluntary contribution? The voluntary contribution is mostly by people who drop money in the collection box, hundis. Who has dropped the money? Nobody is aware. It becomes anonymous donation. Therefore, this, what to say, 115 BBC, charging the anonymous donation to 30% tax is not applicable to a religious trust, wholly for religious purposes. Wholly for religious public trust is not applicable. And it's also not applicable to charitable and religious institutions. It's not applicable to charitable or religious institutions. But then where it's applicable? It's not applicable to religious trust. It's not applicable. Other than anonymous donations for any university, education institution or hospital or medical institution run by such trust institution. Because these type of anonymous donations is collected by practice, they found out it is more the education institutions and hospitals which collect these type of anonymous donations. If they are collecting, for them this section is applicable. Any other charitable institution, if they are going to collect it, it's okay. But if hospital, church trust running an education institution or hospital or university, then they collect anonymous donation. How will they find out? Practically, a charitable institution is doing charitable activities and also running a hospital. They collect donations. Now, will you take the donation, anonymous donation, towards the charitable activities or towards a hospital or a education institution? Just imagine, a charitable institution is carrying on charitable activities. It's also running an education institution. They collect some anonymous donation. The assessee will say, I collected the anonymous donation for the charitable activities exemption. Officer will say, no, you have collected the anonymous donation for the hospital, therefore it should be charged to tax at 30%. How are they going to solve it? Therefore, I'll give you an example for this. A charitable trust running a hospital or maintaining a hospital, running a hospital, is organizing a fundraising program. And the fundraising program is a musical concert. A musical concert where very established, renowned musicians come and perform, and the tickets they charge is very high value tickets, and the huge collections are there. Now, when they collect, assuming if they're going and selling that high price tickets, nobody will buy it unless it is for going for a good cause. There, the charitable institution would say, we are having this fundraising program for the purpose of constructing a hospital or a school, they may say like that, or for maintaining a hospital or education institution. Now, if they make a claim like this, and of course, who has purchased the ticket, nobody will be knowing, because so many thousand people will be buying the ticket at high value. Now, it becomes an anonymous donation, and it is done for the specific purpose of a hospital or a university or education institution. Then this section will apply, 115 BBC will apply, and it will be chargeable to tax at 30% plus surcharge plus cess. But if they collect this money, anonymous donation, not for any of these activities, not for a university, education institution, medical institution, hospital, then 115 BBC is not applicable. So that is what you have to remember. Anonymous donation, this is exemption definition which I already explained to you. Anonymous donation means any contribution received from a person whose identity is not known, no records maintained for the same, address and other particulars of the contributor. I have already explained this. With this, we complete anonymous donation to the extent of threshold limit. This is the last part of it. Assuming I have anonymous donation in excess of 5%, is that 5% excluded and the excess of 5% only is chargeable to tax, or the 5% is exempted? That's the threshold limit. Anything over and above 5% only is chargeable to tax at 30%. But that 5%, does it qualify for exemption? My view is that it qualifies for exemption. It could be a controversy, but my view is that it qualifies for exemption, and you can claim the exemption under Section 11 of the Income Tax Act, provided 85% of that amount you spend it for charitable activities during the year. So what we could do now is, we are 10 minutes to 9. So we have to close at 9. So what I will do, I will run through the questions now. I'll find out if there are any questions. Some of the questions in the course itself I have answered. I think last 2-3 questions I missed out. I will try to read those questions and answer it for the remaining part of the session. And the next one, taxation of accredited income, we will take it day after tomorrow. And the remaining part we will take it tomorrow, day after tomorrow, Thursday evening at 6 p.m. Before that, I've answered Sumit Jain's question. Then Ashutosh Panda, sir, for trust registered under TEL AA, they have to show accumulation more than 15% in Form 10. Yes, to continue availing exemption. Is there any such requirement for accumulating more than 15% in Section 1023C institution? Can we deal 1023C separately, because 1023C is coming up in the remaining part of this presentation. If you go through the remaining part of the slides, I have answered this question. For the time being, I am parking it. I am not answering it. I will answer it when I come to the 1023C chapter itself. I will do that. Apart from that, I think because some of the PowerPoint was not visible, so they answered. They raised a question that is already sorted out. I want one small confirmation. So many people, 25 people, or same people have asked a couple of multiple questions. It's fine. I just want to have a feedback. Feedback in the sense, uh, one is the speed at which I am speaking reaching out to you, in the sense you are with me in understanding. Second, are you able to understand the concepts which I am trying to drive home? Third, do you agree with this type of presentation by identifying important ones by different color, which will help you in revision? So this will help me in structuring my presentation for the subsequent chapters, or if anything else we have to handle. So just give you a small feedback in a couple of minutes, and we'll close the session for the day. I know it has been too long a session. The optimum time would be maximum 1.5 hours, 2 hours. Uh, Beyond that, if it's stretched, the law of diminishing utility starts working. But we have no choice because of this. What say online sessions? We have to go like this. There's no choice here. Uh, if you can answer this question in a minute or so, just those of you who could type it out in the chat box, I'll be happy. Surcharge is 10%, plus that says it works out to 34%, 34.44% it works out, including surcharges. If you go through the presentation in some other slide subsequently, I have mentioned the percentage also. Ashutosh, yes, sir, we can cope with you. All are perfect. Very good. Sumant Jain is very happy. Ashutosh, okay. Anyhow, thank you very much. Hope you have spent the time usefully, and hoping to have more interaction with you on Thursday evening at 6 p.m. With this, we'll wind up for the day. Thank you. Good night. Try to recollect, revise this chapter as quickly as possible, as many times as possible, and then you will get a liking towards the chapter, and you will yourself read more about this chapter. Okay. Thank you and good night. Jay.